And so what the Court of Appeals did here is they came up with a special rule that says, if you waive your right under an arbitration clause, you have to show prejudice, where that's not the rule for any other type of contract. And so going back to the idea the Supreme Court said that this Arbitration Act is only supposed to make arbitration clauses as good as other contracts, but not more so, that's not what they're doing. And so, a bunch of the conservatives on the court have been saying for years, it's the liberals on the court who make up these rules of law, and they say things that aren't really in the language of the statute, and you should always look at the text of a statute. And Justice Kagan, one of the more progressive members of the court, had said a couple of years ago, we are all textualists now, meaning we all look at the text, the language of a statute. And so our question to the Supreme Court is, where did you come up with this idea that you have to show prejudice for an arbitration clause when you don't have to show it for any other type of contract right? Why is there this special rule for arbitration when there's nothing about waiver, prejudice, or any of that in the one sentence that's a substantive part of this statute? So that's really what the fight was about in the Supreme Court.